But with the same allegations.
Correct, exactly. That's what I was advised to do, is the only way to be able to protect that. My hope is that the original, the one that has been canceled or will be canceled, will be sealed, so that's not information that is available to anyone.
Well, that's interesting. Because typically when someone files an order of protection and it's granted and then they dismiss it, an order of protection or injunction against harassment, and then they dismiss it, that's it.
Right.
So,
If there was a way to
What's
remove
going on,
my
everybody?
minor children's names from the
All right,
original.
no time for formalities. Gotta get right into it. Couple housekeeping items, if you guys could help me out. This hearing's in 1 hour. We need to make sure that please, guys, please reach out and inquire what is going on with the courts out there, if they're gonna allow the prosecutors to get away with this retaliation, this obvious retaliation. Did I? It's very possible. What year did I put? Did I put 25? That would be an error, but not anything that probably needs to get addressed right now. Yeah, sorry about that, guys. And thank you very much, Dolores. I will fix those right now. The number right there, give her a call, and ask her. Why don't we do that? Let's see here.
Press 1 to connect to 520-724-3708.
I don't know, DC. You never know.
You have reached the desk of Gina Swecker, JAA to the Honorable Douglas Metcalf, Division 16 at Pima County Superior Court. I am unable to take your call at this time, so please leave your name, phone number, case number, and a brief message, and your call will be returned as soon as possible. Thank you. Please leave a message at the tone. When finished, you may hang up or press pound for additional options.
Hey, good afternoon there. Calling in reference to the Lane Myers situation. Been following this for, I don't know, 6-8 months, something like that. And I'm just hoping that you guys, you make them stop today. You make the prosecutors, you get them under control, and you rein them in, and you say enough is enough. Enough is enough. We can't do this to innocent people. Can't do this to innocent people, guys. It's not. This is not what we do in America. It's free speech. We're talking about state actors. We're talking about reaching out to state actors in their official capacity and redressing grievances. So I hope that I hope that Lane gets a fair trial today, or a fair hearing today. But I just got to look at past experience, you know. So that's why I'm reaching out with the concerns. So hope you guys do the right thing. Dr. Scrolls, wow, thank you. I will let Lane know. It's not likely. Shiz, or something. Is there another screen up? That he'll get back to you today, just because of everything that's going on. Huh. Thought I heard some. I'm hearing things, guys. Alright. Save. Alright, so let's, please, numbers right there. Please, I didn't pin it. I mean, why is this happening? You know, why are they letting it go on? I got a few emails today. Let's see if I'm reading these in the right order for you. Last modified. Might need to start with, this was the first one. Alright. So forgive me, my son is on the wall right behind me. Yeah, I'll text him about that, Dr. Scrolls. Can you tell me what the email's about, or okay. Who gave me the $19? Who the heck is that? I didn't see that. Twice, bro. Thank you very much. I just texted him. Okay. Let's read this. Let's get through these. Please reach out and let everybody know. The number's pinned, please, guys. No, the hearing starts in an hour, 1:30, and this is a revocation hearing for his bond, and to decide whether or not there's going to be an open and public trial, if there's going to be free press in America, or if because Lane is being charged, if everybody has lost the rights. Lane's set up to lose, 45 to life, but they're going to steal everybody's rights while they're railroading him. So, defendant's Rule 15.2b disclosure. Mr. Myers files the defendant's 15.2b disclosure. Rule 15.2b reads as follows. Notice to defenses generally by the deadline specified. Indeed, the defendant must provide written notice to the state specifying all defenses the defendant intends to assert at trial, including but not limited to alibi, insanity, self-defense, defense of others, entrapment, impotency, marriage, insufficiency of prior conviction, mistaken identity, and good character witnesses. For each listed defense, the notice must specify each person other than the defendant that the defendant intends to call as a witness at the trial and support of the defense. Oh no, this is Never mind, sorry. 3, signature and filings. Defense counsel, or if the defendant is represented, the defendant must sign the notice and file it with the court. Rule 15.2, the defendant's disclosures. Arizona Rules of Criminal Procedure. Thank you, NAFO Radio, P15.2. Asserted defenses. Anti-SLAPP law, ARS 12751. Mr. Myers will be filing a 40-page anti-SLAPP motion in the next 24 hours from this filing. This criminal prosecution is the most egregious and unlawful prosecution ever initiated in the history of the state of Arizona. This should result in disbarment of Rachel Stiles, just like what happened to April Sponsel in Maricopa County. April Sponsel attempted to charge felonies for First Amendment protected activities and lost her license to practice law. That is exactly what needs to happen to Rachel Stiles for bringing these charges against Mr. Myers in an explicitly malicious way in an effort to deter and to retaliate against Mr. Myers News Media Corporation, Freedom Productions LLC, because they cannot legally have the videos removed. They are legal news journalism protected by the First Amendment, and a long list of publishing and copyright laws. Sorry. Dr. Scrolls, I'll be live through the hearing. Lane, I will not be. I'm not gonna be video. I don't have courtroom access. That's what this hearing's about. Is about the revocation of the bond, and then I put in a request to record, and that's what they're going to talk about. So Lane is going to broadcast under 122H. Maybe I'll bring his live over here, but I think the answer is no. I'm not going to have video or anything like that. So instead, Rachel Stiles thinks she can charge Mr. Myers with 14 felonies and many felonies criminally to try and scare Mr. Myers into taking the videos down or having this court order them down. This court cannot order them down, so this is a complete waste of time. Mr. Myers will be sitting in prison and the videos will still be up, along with hundreds of more videos about the entire case on channels around the world. The longer the case goes, the more videos there will be about the alleged victim. That's true. So, and guys, if you have videos that you're publishing on your channel, please send them to me. Send them to me. I will. I'll share them with my audience, because what is happening here is a miscarriage of justice. What is happening here should not happen in the United States of America. What's happening here? Thank God, it's somebody like Lane that is willing to stand up and knowledgeable enough to stand up in a way that they should lose, right? They should do the right thing just because he's Aaron Queen? Are you trolling? You think he should go to jail for talking, dude? Okay. We know what kind of warped morality you have, bro. You're not following closely? Alright. Fair enough. Well, nobody should be jailed for speech. Period. State of Arizona employees are not allowed to put criminal charges on someone for First Amendment protected activity. This is only because the state of Arizona employee is married to the Tucson city prosecutor. Mr. Myers exposed Matt Walker multiple times in several criminal cases for prosecuting Mr. Myers without probable cause for First Amendment activity. This now willful and malicious retaliation targeting Mr. Myers to try and get the videos removed exposing Matt Walker. This case has nothing to do with the alleged victim. This is Matt Walker offering his wife up as some sacrificial lamb victim to try and silence Mr. Myers from being able to expose what really goes on at Tucson City Court. Facts, bro. By charging Mr. Myers, the most vocal critic of the local public employees, the state is hoping to deter public participation by scaring everyone to chill their First Amendment protected liberty interests, or they could be charged next. Give him a call, guys. Give the judge a call. Please. Give the judge, please, guys, I'm imploring you. I'm imploring you, please reach out to the judge and express your concerns with what's happening here. They need to know that we're all paying attention. They need to hear our voices, or it makes it easy for them to lock them away and to hide it all. We can't let it happen, guys. We just can't let it happen. All the individuals involved in this prosecution have never charged a single other person in their entire life for the same activity. This is a clear targeted retaliation against Mr. Myers intended to deter, retaliate against the First Amendment activities, to chill public participation in the legal system. The very thing the anti-SLAPP law ARS 12751 was intended for. Mr. Myers will have that anti-SLAPP motion filed in the next 24 hours from 3/19/2025 at 10 a.m. It's today, so that'll be up tomorrow at the latest. Factually innocent. Based on a strict reading of the facts, Mr. Myers has not committed a single element of any criminal statute. In fact, Mr. Myers has not even violated a single civil legal standard. The alleged victim has been to 5 civil judges already who said they can't have these videos taken down because it's First Amendment activity. Get your mind right, Shannon. Get your mind right. Legally innocent. Based on a strict reading of the direct indictment, these charges are insufficient as a matter of law. Not one single charge in the direct indictment is supported by probable cause or comes even remotely close to being the correct charges, even if alleged criminal acts possibly, maybe, even remotely came close to allegedly happening. Count 14, stalking, fear of death. Get the fuck out of here with that bullshit. How the fuck can a voicemail lead someone to fear death? A voicemail at the place of public employment during business hours asking for help in a legal matter. Stop the cap, as the young kids say. This isn't even something you could get 5 civil judges to order taken down. This isn't even something they could get 5 civil judges to order taken down. Then the final injunction is also unlawful because it contains one act, and that act was protected activity by law. This case is going to show everything that is wrong with the Pima County Attorney Office. Lane Jeffrey Myers will be the one to expose this corruption to the whole world live in Judge Metcalf's courtroom. This case is going to show the whole world how lawfare works when you are married to the prosecutor and the prosecutor wants revenge for Mr. Myers exposing him. What? Witness. As of the filing, Mr. Myers doesn't plan to call any witnesses because this case will be quickly dismissed, and Mr. Myers has not received the state's actual allegations against Mr. Myers. Mr. Myers will file an updated 15.2b if necessary within the required time period. Mr. Myers is filing this 15.2b notice immediately so the court can see exactly what is actually taking place in this case as soon as possible in order to have the required information to make decisions that impact the future decisions. There will be an anti-SLAPP motion filed before the end of the required period of notice under 15.2b. Mr. Myers is completely innocent, so he can file this notice immediately and let the court, it's going to be hearing innocent beyond a reasonable doubt early and often. No, Aaron, I don't want to make a wager on Lane's freedom. Thanks, man. Thanks. If there's justice, this is Lane's going home, right? And at the very latest, it's going to be dismissed at tomorrow's hearing at 1:30. But I mean, you don't know, right? I mean, do we know if Judge Metcalf is corrupt? Or corrupt? We don't know that yet. We'll see today, I guess. We'll see today. There's been a long list of judges. So far, I only know of. Does anybody know of another judge out in Tucson that is honorable, other than Riojas? So Riojas was honorable. Is Judge Metcalf, is he honorable? Less than 45 minutes. We'll find out. Oh, Sassy, you didn't miss anything. We're just going. Actually, you did. You missed it. You missed a lot. There's a number pinned at the top. If you could just leave the chat for a minute, leave the video. If you could give that a call, and let them know that we're watching. We're all watching. Lane is still free. Yeah. As of 3:51 Eastern time. Motion to compel production. Motion to compel production. Mr. Myers moves this court to compel production of the state's required 15.1 disclosure, specifically and immediately the exact nature of the allegations against Mr. Myers is facing. Mr. Myers has absolutely no idea what the nature of the allegations are against him. Rule 15.1G allows the court to order an immediate production. G. Disclosure by the court disclosure by court order. Disclosure by order. On the defendant's motion, a court may order any person to make available to the defendant material or information not included in this rule if the court finds A, the defendant has a substantial need for the material or information to prepare for the defendant's case, or B, and B, the defendant cannot obtain the substantial equivalent by other means without undue hardship. 15.1, the State Disclosure Arizona Rules of Criminal Procedure 15.1. Mr. Myers has a piece of paper labeled direct indictment. It lists 14 counts. Several of the counts don't even articulate what the allegation is in the count. The rest of the counts simply use boilerplate words like video and voicemail. Count 14 lists a series of events. What events? In order for Mr. Myers to comply with the conditions of release regarding the videos needing to be taken down that contain alleged crimes, Mr. Myers needs to be told the exact date, name, and timestamp of the video that he is being prosecuted for. That is both for the ability to comply with the conditions of release as well as prepare a defense against these baseless allegations. How is Mr. Myers supposed to know what the nature of the allegations are based on a plain reading of the indictment, the only document Mr. Myers has related to the charges? The state should have a very detailed and exact list of the exact moment the crimes occur in the video. Mr. Myers could have a 7-hour video and it only has 30 seconds of the alleged victim in it. If Mr. Myers is told the exact timestamp of the alleged crimes, he can edit that part of the video out and leave the rest of the video. All the videos in question are owned by Freedom Productions LLC, a media corporation. They are very strong copyright and publishing laws, along with the right of free press that this court is going to have to violate in order to remove these videos from Mr. Meyer's news channel. Therefore, before possibly infringing on unlawful behavior by the judge by ordering the removal, this court needs to order the state to produce an exact list of the exact time in each video the crime in each count is to have allegedly occurred. Conclusion. Seriously though, guys, if you could just give that call, or give that number a call. Bad Apple Media says that request would be done here in Michigan as a bill of particulars. I'm not familiar. Bad Apple. Gourmet. I'm not sure what that means. I'm sorry. What gore is. That's okay, Sylvia. Charge your phone so you can at least hear the 122H hearing when Lane comes back. Conclusion. Please call, though. Please call, and we need to find out who exactly has bumped their heads. Is it the judge? I mean, the prosecutors, they're way, way, way off the reservation. But reach out, guys, please. Conclusion. This is nothing more than a giant waste of time by the state, and this court better report Rachel Stiles for professional misconduct. Nobody in the history of the state of Arizona has ever been charged for making news videos about employees of the state of Arizona. The state cannot be a victim. Wake up, people. Order the immediate production of the exact nature of the allegations against Mr. Myers, both to comply with the conditions of release and to prepare a defense of the baseless allegations. The state hasn't even told Mr. Myers what the exact charges are, and they are already accusing Mr. Myers of violating the conditions of release. Mr. Myers will expose every single person involved in this as the corrupt legal professionals they are. There is no such thing as secret hearings or secret courts. Wow, Dr. Scrolls, appreciate that, bro. Bad Apple, I'm too ignorant to make a comment on that comment that you just made. Lane should have never allowed them to have jurisdiction, no charges. I can't speak to that. I'm ignorant about that. But fuck, Dr. Scrolls. Seriously, bro. Judicial notice of adjudicative fact. Mr. Myers files this notice of adjudicative fact in this case to notice of the court of the following very critical adjunctive facts in this unlawful prosecution. Rule 204 of the Arizona Rules of Evidence reads as follows. A. Scope. This rule governs judicial notice of adjudicative fact only, not a legislative kind. B. Kinds of facts that may be judicially noticed. The court may judicially notice a fact that is not subject to reasonable dispute because it, 1, is generally known within the trial court's territorial jurisdiction, or 2, can be accurately and readily determined from the sources whose accuracy cannot be reasonably questioned. C. Taking notice. The court, 1, may take judicial notice on its own, or 2, must take judicial notice if the party requests it and the court is supplied with the necessary information. Timing. The court may take judicial notice at any stage of the proceedings. E. Opportunity to be heard. On timely request, a party is entitled to be heard on the propriety of taking judicial notice and the nature of the fact to be noticed. If the court takes judicial notice before notifying a party, the party on request is still entitled to be heard. Rule 201, Judicial Notice of Adjudicative Facts, Arizona Rules of Evidence 201. Adjudicative fact. 1. No previous relationship. Shannon, you only dated Lane in your dreams, in your fantasies. That's the only place that you and Lane have spoken to each other and shared niceties. Mr. Myers has received a police report from Rachel Stiles that lists Mr. Myers as being Shannon Walker's ex. Mr. Myers has never met Shannon Walker in his entire life. The only time Mr. Myers has ever even seen Shannon Walker in person is at 2 court hearings in Superior Court. The indictment also lists count 14 as stalking, fear of death, ARS 13-2923A2, which reads as follows: reasonably fear death or the death of any of the following: a person with whom the victim has or has previously had romantic or sexual relationship. Shannon. Come on, Shannon. What are we saying here? What are we saying? Are we saying that you guys are raising Lane's little rugrats? Is that what's going on, Shannon? Is that what is going to be revealed to all? Check out that dirty mullet. Check out that dirty mullet right there. Holy smokes, that's a dirty mullet. Oh man, those are dirty. Dirty ass mullets. Shannon, come on, you didn't date Lane. Gee, just think about that. Think about how twisted that is. That's the only way that they can twist this into such a serious charge is by lying about something that's pretty fucking serious, right? But is it a big deal? No big deal. 14 charges, 8 felonies. Mr. Myers has never even met Shannon, let alone previously had a relationship, especially a romantic or sexual relationship. The fact that a police report lists Mr. Myers as Shannon Walker's ex and Mr. Myers is charged with a crime related to being in a previous relationship requires this court to take adjudicative notice of the fact that Mr. Myers and Shannon Walker have not ever even met outside a court hearing. Adjudicative fact 2, Shannon Walker. Employment status. Mr. Myers is noticing this court of the adjudicative fact that Shannon Walker is an employee of the state of Arizona. All communication alleged in this matter involve communications related to Shannon Walker's employment with the state of Arizona during business hours on publicly available contact information listed on the state of Arizona website. Simple as that. Couple clicks. law.arizona.edu. Edu. Public. That's public. That's public, everybody. Public page. These communications all concern a matter of public record and public interest concerning employees of the state of Arizona. Adjudicated fact number 3. Freedom Productions, LLC. Mr. Myers files this adjudicated fact to notice the court that all the videos related to this criminal prosecution are owned by Freedom Productions, LLC, not Lane Myers, the named defendant in this unlawful prosecution. All the material is owned and controlled by Freedom Productions, LLC, and Arizona Media Corporation. Mr. Myers has attached the ACC website as proof, Exhibit 1. Mr. Myers cannot be held criminally liable for something a corporation does until the courts have declared the corporation's activity unlawful. No TRO or permanent injunctions have been filed against or issued against Freedom Productions, LLC regarding the videos. If the alleged victim had an issue with the videos being criminal or unlawful content, why haven't they asked for an injunction against the corporation that is publishing the videos? Because they will get laughed out of court, just like the previous times they tried to have the videos removed. Civil court even has a lower standard of proof. Should be easy if they really are unlawful, but they're not. They're not unlawful, though. It's First Amendment protected activity. That's what it is. So, actually went through that a little faster than I anticipated. Let's give the judge a call back. Dolores, if you're still in here, I really appreciate you letting me know about the dates on that. What am I doing here? Warren, where's Warren? Warren, you in here? You in here, Warren? Warren. Warren.
You have reached the desk of Gina Swecker, JAA to the Honorable Douglas Metcalf, Division 16 at Pima County Superior Court. I am unable to take your call at this.
Did they send us to voicemail? Is that what happened there? Let's just make sure. It feels like I got sent to voicemail.
Please press 1 to connect to 52. You have reached the desk of Gina Swecker, JAA to the Honorable Douglas Metcalf, Division 16 at Pima County Superior Court. I am unable to take your call at this time, so please leave your name, phone number, case number, and a brief message, and your call will be returned as soon as possible. Thank you. Please leave a message at the tone. When finished, you may hang up or press pound for additional options.
Hi there, I'm calling in reference to CR 2025160-001. Really, it's coming down to the wire here. It's coming down to the wire where we find out if Judge Douglas Metcalf is honorable or not. We find out if he's going to hold the prosecution responsible for the lies that it's told, for this egregious, these egregious charges. I hope that the judge has had time to read through all the filings here and that he makes quick and embarrassing work out of Rachel Stiles and the Pima County Prosecutor's Office. All right. Thanks. Have a great day. I'll give you a call after the hearing. Of course, I heard about Warren Sapp. Warren Sapp is responsible for me changing the acronym. It's not RAPS anymore. What is it? Does anybody know? It's RSAP now. Yeah, they did him dirty over there, huh? Well, last time Brooks' court goes were because of she on one did not care about the other. The president had no criminal record. That's good. What time is the hearing? The hearing is in 21 minutes. Do we have a Google Meet link? Sassy, we do not have a Google Meet link. Lane is going to be the only, he's going to be the only, our only hope to hear the hearing today. So today's hearing is about, for those of you just coming in, today's hearing is about revocation of Lane's, I guess it's not bond, it's to change the conditions of release. They want the conditions to be Lane in jail. That's the condition they want. And to discuss the media request to be in the courtroom or to record all of the hearings. Sassy, audio allowed because of 122H. Yep. Bruce, what do you think? Do you think if I would have left my name, they would have called me back? They didn't call Joey back. I'm very skeptical. John's live. Is he? No. No. None of those people are alive.
You have reached Shannon Walker, Director of Special Projects at the James E. Rogers College of Law. Please leave a message and I'll call you back as soon as I have a chance. Thanks.
Hey Shannon, I know you think hiding behind the website and all that's going to stop this, but it's not. It's only going to keep going, and you're just going to get yourself and the university in more and more lawsuits and more complaints, and you're just literally bringing more attention on yourself by avoiding making a comment. If you want to make a comment for the story, you make a comment and then it goes away, and then if we contact you after that, then you have standing. But this hide and lie and manipulate and go behind back channels and have your husband try this and that, it's not going to work. Unless you quit your job at the U of A, you're going to face this public scrutiny. So you can hide your number, you can do all that, it's not going to change anything. Everybody knows where you live, everybody knows where you work, nobody's trying to hurt you, Shannon. We just want information. We just want information. You live, everybody knows where you work, nobody's trying to hurt you, Shannon. We just want information.
That's what
you live, everybody knows where you work, nobody's trying to hurt you, Shannon. We just want information.
You need to send that to Shannon.
Unless you quit you can hide your number. Unless you quit your job at the U of A, you're going to face this public scrutiny. Everybody knows where you work. Unless you quit you, Shannon. Unless you quit work.
There we go.
Everybody knows where you live. Everybody knows where you work. Nobody's trying to hurt you, Shannon. We just want information. Everybody knows where you live. Everybody knows where you work. Nobody's trying to hurt you, Shannon. We just want information. Everybody knows where you live. Everybody knows where you work. Nobody's trying.
We're out here today to ensure our. Nobody's trying to hurt you, Shannon. She fears death right now. That's what she's trying to tell people. She fears death. Is that serious? Is she serious? She fears death? No, bro.
James V. Rogers College of Law. Please leave a message and I'll call you back as soon as I have a chance. Thanks.
Good morning, Shannon. My name is Lane Myers. I'm an independent journalist. I'm doing a story regarding a case that's taking place in Tucson. I was wondering if you'd like to put a statement on the record whether or not you had any involvement in my wife getting fired from her job. You know, I'm giving you the courtesy of, I'm willing to quote you directly, but instead you guys want to hide and play games and use the legal system and hide behind fake injunctions that are going to get dismissed and all this kind of shit and try to violate my rights. I can come to the law school. There's nothing that can stop me by law. And so, like, you know, we can do this like the easy way, the expensive way, or like the uncomfortable way, but you're a member of the University of Arizona faculty. You're a public employee. I'm a journalist. I have the right to free press. I want to ask you, you can have the media department, whatever. If you don't want to, your actions indicate guilt. I'm giving you a chance to say, hey, I know it looks wild what's happening, but that's not true. But instead you want to run and hide, that's fine. You have that right. I'm not going to hurt you. I don't have nothing. But in a working capacity, I am going to, you know, attempt to get a quote from you. And if you don't want to give a quote, then just say you don't want to give a quote. But either way, I have the right to question you. And you can't weaponize the fake court like you and your husband, or like Stacy and your husband, all that shit. It's not going to work. You're just going to get sued. So, public employee, public scrutiny. Welcome to the real world. It's called, it's when you're an adult, you have to deal with scrutiny.
We're out here today to ensure. Guess it's gonna help if I turn the microphone on, huh? Grande. What are you talking about, Grande? Are you related to Grande Johnson the First? Why are we fighting in the chat? Sassy Queen, you are right. Laura Conover's terrible. Am I logged in the... See if I'm logged in here. Fuck. I don't know my password, so it's not gonna happen right now. Those are new, Greg. I tried to add that as the little light bulbs. It didn't quite turn out how I wanted it to, but listen, I'm a work in progress here. Alright, well, shit, man. What should we do for the next 10 minutes? Should we call the court back? Let's celebrate your 20th Super on a live stream. Alright. Celebrating. I need to be celebrating these. Let's be real, right? Need to celebrate the fuck out of those. Thank you very much again.
Who's the judge? Judge Hampton's going to let me see the site here. See what? All right. Yeah, sit here. That way you're with the Where's the chance to speak? All right.
What is wrong with felons? Is it? It's the old cart and the horse and the apple and the tree scenario. Were they bad before they were the felon, or is it the felony that makes them the badness? I don't know. You gonna start talking to me?
This is William Parvin. I've been appointed to represent Mr. Myers. However, Mr. Myers would like to file a motion to represent himself. He's not sure exactly where to file that. He can file in this court today, or if he has to go downstairs.
Okay, good afternoon, Mr. Myers.
Good afternoon, ma'am.
This is the time set for your arraignment. We're going to proceed with your arraignment first, and then I'll talk to you about your motion. So is your true name Lane Jeffrey Myers?
No, I sit down.
You can sit down.
You can be seated.
Yes, ma'am.
Okay. On the document there in front of you that your attorney has with the criminal charges filed against you, we are going to enter pleas of not guilty on your behalf. I am going to appoint OPAC attorney William Parvin to represent you for now. I'm going to assess $400 in attorney's fees. Your next court date is your case management conference, April 15th at 9 a.m. And then your pretrial conference is set May 16th at 9 a.m. Those are both in front of Judge Doug Metcalf, Division 16. You are ordered to appear at both of those hearings. Failure to do so can result in a warrant being issued for your arrest and a trial going forward in your absence. If you cannot be convicted, if you are convicted at that trial and cannot be sentenced within 90 days, you could lose your right to a direct appeal. And so, Mr. Myers, because I am not your trial judge, I'm going to ask you to file any motions that you have with your trial judge, which is Doug Metcalf, Division 16. I am also going to set a status conference next week in his division for your motion to proceed pro se.
Thank you.
That'll be March 20th.
After I file it, right?
March 20th at 1:30 p.m. in Division 16, and I'll write that on your paperwork here.
Thank you. Do I need to file it ahead of time or bring it with me there?
I'll let you talk to your attorney
All
about
right,
that.
thank you.
I think you can still file on the second floor criminal cases. I use the online system, but I don't think you're set up for that.
I'm not.
So go to the second floor and
It's the
file
last
everything and tell them
room.
where it
This
needs
is
to go.
not
to the
Okay.
Judge.
All right, yep.
And you've already served copies, you told me.
Yep, on to Rachel.
Okay.
And then also give one copy to the chambers of Judge Micklef. They'll talk on the first floor how to do that.
Okay.
By the way, there
Status
is.
conference regarding your petition to proceed pro se is March 20th at 1:30 p.m. and that is in Division 16. And then we also need to set conditions of release before we talk about that. Mr. Myers, you are ordered to report for fingerprinting and photograph on the 7th floor. You can do that before your first case management, or you can do that today.
7th floor?
7th floor. Does the state wish to be heard regarding the release?
Yes, Your Honor. Your Honor, the state is asking for a $25,000 bond and pretrial services release if that is posted. We're also asking for numerous conditions of any release. And I'm going to go through.
Yeah, Greg, no public hearing today, although Lane will be broadcasting.
Under Rule 7.2 of the Arizona rules, that the release conditions, somebody is to be released on recognizance unless the court determines additional conditions are reasonably necessary to assure the defendant's appearance, or to protect the victim, any other person, or the community from risk of harm by the defendant. And so we are asking for additional conditions. In this case, we're asking for no contact with the victim to protect her from physical harm, harassment, intimidation, or abuse. The court can also order additional conditions, including to protect another person or the community from risk of harm from the defendant. We believe that a non-monetary condition is not sufficient, so we're also asking for the monetary condition of the $25,000 bond. That's
What's
both
Bunny's
for the
problem?
reason that Mr. Myers is facing mandatory prison time if he's convicted of
What's
these
your problem, Bunny?
offenses. He does have prior felony convictions that, while older, will make him prison mandatory even on the first felony offense, and each subsequent felony offense he faces mandatory prison time. These are also offenses that can be stacked, so he's facing a large amount of time. Also, he has had an injunction against harassment on him already, and so he's been court-ordered not to have contact with this victim, yet in spite of that, he has
What's your problem, Bunny?
continued to have contact with her, reach out to her, ask for third parties to reach out to her. He has been posting about this case. He has been bringing attention to her, which has been subjecting her
To be clear on
harassment
this
and
also,
intimidation.
Lane's never asked me to reach out to anybody. Ever. He would never have to. I'm not blind, you know what I mean? I can see what's going on. So I don't need prompting from him to do anything. So he's not encouraging third parties to do anything. I do this because it's the right thing to do. It's an injustice done to one man is an injustice done to all of us. So we can either be like Bunny and say, oh, because he what nonsense? Nasty crackpot. Support a nasty crackpot. So being a nasty crackpot is against the law now. I don't know. I guess so. I guess we'll throw people in jail for acting in a way that isn't criminal, but isn't like everybody else. That sounds smart. I don't think Bunny's blocked. It would say it. Bunny's not blocked. Bunny disappeared. See? Bunny's still good to go. Bunny, you know, Warren, is that Bunny's backup? Is it Warren?
Mr. Myers himself, even after receiving the summons in this case, reached out again through an email he sent to the victim in this case. He again was online talking about this case, drawing attention on that post. That the posting was done by a third party, but he did participate in that post and was on that post. In that post, it posted again the victim's email address. It was asking for people to reach out to her. Her husband is also subject to that. And so we are asking for these release conditions of not just non-monetary conditions, but monetary.
Sassy. That's such a great idea. Nobody would dare block Warren. Warren, is that you? Warren, I needed to let you know, since it's a two-party consent state, that this phone call is being recorded. Warren hung up. Warren. 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 Maybe it was a mistake.
Connect to 716-461.
I'm sure I've got people blocked too. 4:30, y'all.
Yeah, hi, this is Lee. Please leave a message at the sound of the beep.
At the tone, please record your message. When you've finished recording, you may hang up or press 1 for more options. To leave a callback number, press 5.
Well, I was trying to reach Warren, but it sounded like the voicemail said Lee? Is that right? Lee? Okay, well, it's Foshin, 407-502-8862. Give me a call, Warren. I mean, Lee. So, okay, Warren. Alright. Warren's a troll, Chad. Here, I'll show you. Where was that? That was in the 80-page document from yesterday. That's where that was. Who is Warren? You say. So Warren left some voicemails. Warren sent some emails. A lot of emails. Warren sent a lot of emails. Why does he keep doing that? So here's one of his voicemails. Listen, and he's calling me a psycho. Listen to this lunatic. Yeah, hi Shannon. This is another curse. Nobody has called Shannon Walker more than Warren. Nobody's emailed Shannon Walker more than Warren. If anybody's harassing Shannon Walker, it's definitely Warren. And Warren he's saying all kinds of shit, and he really makes her feel as if there's some true threat against her or something. But let's just let's never forget. I thought I'd have it handy, but I don't, so I can't do it. Maybe I can. Hold on.
Everybody knows where you live. Everybody knows where you work. Nobody's trying to hurt you, Shannon. We just want information.
That's it. That's it. Get your mind right, Shannon. So this is this guy. Another courtesy call concerning the psycho This is a public service. A psycho. He put up a video about you. It actually wasn't about her. I mean, she was mentioned in it, but the video was about the injunction. Text went through, so he hasn't been arrested. For sure, to AJ. And he boasts that he lives in Kissimmee, so, I wish he'd come out and, I'm not a mean guy. I'm approachable. I think that maybe Warren and I could come to an understanding about things, I have Warren's number. I have it. I have Warren's number because Warren called Shannon and I got Shannon's calls. So, sent the voicemails. Here's an email. Here it is. He's a YouTube channel watcher. He's been watching Lane. And without a doubt, conveys signs of schizophrenia and illegal drug use. And he can make that claim because of his long experience as a YouTube watcher. All right. So that's who Warren is. Warren is somebody that I don't know actually what his deal is. Does he think that he just hates freedom? Is that what it is, Warren? Do you just hate freedom? Or you think that the brand of freedom that we like to exercise is too much freedom? So I wonder how much tyranny is okay in Warren's mind. Oh, he's in here for sure. For sure. Where'd it go? For sure. There you go. His X Lane. Where's the tab go that I was using now?
As far as the non-monetary conditions, we are asking for him to not possess any firearms. In the most recently, he talked about wanting to get a firearm. Given the safety risk in this case, we are concerned if he were to get a firearm. We're asking again for the no contact with the victim. We're asking for no contact with the victim's family, including no contact through any third party. We're asking for him not to be able to access the internet. He has been actively using the internet as a way
He asked Lane for a wrench.
to harm other people, to intimidate any potential witnesses, to intimidate judges, to intimidate prosecutors. He has been posting, asking for people to go to people's homes and to go to their workplaces and to reach out to them. So I believe any further access he has to the internet will put people at harm. He can go, even if he represents himself, to the law library and be able to access what he needs to be able to do legal research. We would ask, if the court's not willing to just do no access to the internet, that he not be allowed on social media or to request third parties to post anything on social media regarding this case. We are asking that he not have any contact with anyone at the U of A School of Law, that anybody he contacts at that place of employment for a victim, he has been going to her place of employment and reaching out to those people and talking to them. It's part of an intimidation strategy. The people there are feeling uncomfortable and unsafe because of his targeting of those, and we would ask also for that to be that no third person or third party can do that on his behalf either. We're asking again for him not to have any contact with the city prosecutor's office regarding Matthew Walker, or for him to go through a third party, because again, he's been targeting Matthew Walker, who's the spouse of the victim, and been targeting his office. Obviously, if he has a legitimate purpose outside of just asking.
Is she asserting there that now Matt Walker is protected? The prosecutor is protected from redress? You gotta be kidding me.
People to reach out to Matthew Walker, that would be separate, but to not have any contact with him. And we're also asking that he not be able to disseminate any of the disclosure in this case. Mr. Myers did contact me and sent me an email where he indicated that was exactly what he wanted to do, wanted to stop the disclosure in this case, because he wanted to disseminate it on the internet so that everybody could look at it, which again would cause further harassment and intimidation of the victim. It also will put any potential witnesses at risk, and it's going to create problems for if this case were to proceed to trial of getting a fair jury pool who hasn't seen, who currently wouldn't know about the case, but if they sit there and read all the disclosure in the case and that is readily available, it's going to risk us being able to have a fair trial in this case. So again, we're asking for no contact through,
No, I'm not mentioning that today.
well, I just went through those. So let me talk about some of the factors under ARS 13-3967B. The things that court can use in determining method of release or the amount of bail, are the things that court should take into account. And I'm going to go through the ones that I feel are applicable to this case. One, the views of the victim. She has been subject to constant harassment and intimidation as a way to try to pressure her to not go forward with this case. And I do want to be very clear that Ms. Walker has not brought this case, that the state of Arizona is the one pursuing this prosecution. The state of Arizona is the one bringing this case. The victim, regardless of whether she wants to go forward with this case is absolutely going forward through the state of Arizona. The nature and circumstances of the offense, once again, we have repeated harassment regardless of court orders and in violation of court orders. And again, he's facing mandatory prison time. We have evidence the accused poses a danger to others in the community. Again, in this email, he decided to provide to me a list of people that he's been filming in the community. He gave me a list of that he has videos about, to include 7 federal judges, 13 local Pima County judges.
So right here, Rachel is going to tell us all of the other people that he's done the exact same thing to, but hasn't been charged for. All right, let's hear the list.
To include 7 federal judges, 13 local Pima County judges, 5 local prosecutors, 25 local members of law enforcement, 18 employees of the city of Tucson, 39 employees of Pima County, the FBI, 10 U.S. Marshals, 20 U of A employees, and 15 U of A police. So this is a list he provided.
That's 152 people plus the FBI, if my math was right. So he's done the exact same thing to at least 52 other people and has not been charged for one of them. Okay, Shannon. Okay, Rachel. Cool story.
To the state, indicating the people he's been videoing. We have witnesses who are scared and intimidated, and people who do not want to come forward because of the fact that he's been targeting them, and they're concerned that they're going to be posted on the internet and have a lot of people coming after them. Like I said, he has targeted everybody involved in his criminal cases, including posting addresses of theirs online. And
not true.
Number 6 under 1339
unless it was public.
B is 6 weight of the evidence of the accused. The state has very strong evidence of all of his crimes in this case. He's been live streaming about them, so we have video evidence. We have his admissions. Just yesterday, he went on and went through every single charge, talking about what he did to commit those offenses. So the state has very strong evidence against him, and we also have the records from the court. And then number 12, the accused record of arrests and convictions. As previously noted, he does have prior convictions, which makes him facing mandatory prison time, and he has a lengthy arrest history. And so, for all those reasons, we are asking for these more stringent release conditions, because I think it's necessary to protect the victim and others in the community and other people connected with this case. And then I also want to point out the Arizona Constitution 2.1, the Victim Bill of Rights. The victim is to be treated with fairness, respect, and dignity, and to be free from intimidation, harassment, or abuse throughout the criminal process. And just from him getting a summons, he immediately targeted again the victim and immediately was calling upon third parties to engage in harassment, intimidation, and abuse towards this victim. And so these release conditions are necessary to protect the integrity of this case, to protect the integrity of the system, to allow people to maintain confidence in the judiciary system, and above all, to protect the safety of our victim. So, thank you. Mr. Parvin?
Yes, Your Honor. First of all these are available as a matter of right. No violence has been alleged. A lot of this may have some free speech issues. I realize there may be strong evidence perhaps of something, but there's been no convictions, and the state's alleging already class 5 felonies for prior convictions. There's also an appeal pending of that injunction, which it may not have been valid in the first place. That may be some of the contact, because Mr. Myers, through the appellate process, has to serve Ms. Walker. I don't think Ms. Walker is represented in that case. I may be wrong, so he legally has to give her those documents for the appellate process. Also, YouTube, it's all over the place. We don't know who's posting. It's not just Mr. Myers here. Again, and also there's court camera, there's all sorts of things all over, both on shows, on TV. Again, I haven't heard anything about any violence or specific threats to safety. I know there are a lot of charges, but a lot of them are related. In fact, some may even have some double jeopardy concerns based on what happened in another court, that there's also, well, it should be special action proceeding, but that's a different issue. My suggestion is that release conditions sufficient to make everybody happy is release to pretrial service with a condition, at least, and this is not a violation of your First Amendment because you have a right to a speedy trial. Pending the outcome of this trial, keeping in mind your speedy trial rights.
I'll agree.
No blogs.
I'll agree.
No, take down all videos.
I'll take the videos that are listed down.
Everything, no communication. We can't control what other YouTubers do. But Mr. Myers can at least, to respect this court, the victims, and release conditions to alleviate concerns while this case is pending. Again, that's not a violation of your rights. It's an exchange for not being in custody.
I agree.
No internet at home, no YouTubing. You just stay in contact either with me as advisory counsel, if you represent yourself, or me as your attorney.
Yes, sir.
And that should alleviate any concerns, Your Honor. And if there's a violation of that, then we can come back and talk about it.
If it's as simple as like removing the videos that are continuing to be alleged as harm, take them down. Then once we figure out is it free speech or a crime, we'll deal with that later.
Let's solve your cases first.
Right, okay.
Your Honor, just that he has been ordered to have no contact and do these things before, and yet he has continued to do them. And like I said, as of yesterday and today, he's been continuing to go forward on harassing this victim.
He's never been ordered not to make a video. I think that's a.
Hey, Bad Apple. It's not that nobody cares, bro. It's that it's not about you right now. You know what I mean? If you can send me something that is digestible, that I can, consume, and that it isn't going to take me forever to consume, to like let me know what's going on, that's one thing. You know what I mean? But yeah, all these people, everybody in this chat, they're here for Lane, right? They're here because they're worried about what's going on with Lane right now. He has a court hearing right now. It's going on right now. Every other court hearing he's ever gone to, he's already been live. He's already been live. So we know something's going on, right? We know that something bad is happening, right? Because it's not going as it always goes, right? So, you know, just, I guess just be aware, man. Like, nobody's saying, oh, we're not concerned for what you've got going on or the struggles that you're dealing with. We're just, like, we're not, that's not what this is about right now, bro. So, yeah, I'm not trying to start shit with you, but yeah. So I'm concerned right now. I'm worried right now.
Legal issue down the road, but that's why, to alleviate concerns, I think my recommendation, or our recommendation, is fair, Your Honor.
Thank you, everybody. So I am going to release Mr. Myers to the supervision of pretrial services. No contact of any kind with the victim or the victim's family. Do not go to the victim's residence or workplace or the victim's family's workplace. Take the videos down of the victim.
Specifically the ones that are alleged in the summons, right? Not all my videos that she read off, right?
Take everything down in this case to be safe.
Anything related to the victim.
The victim.
Yeah. All right.
Yep.
That's it for today then.
Thank you.
Everybody.
Thank you, Your Honor.
And, Your Honor, can we also make sure that he's directed that he's not to have a third party do anything?
So the hearing's already over at this point.
Means not directing to somebody else, because what you're doing there is subjecting that third party to a crime. So if these are your friends, you don't want them to be convicted of a crime as well. So no third parties can contact the victim.
And Your Honor, would you please advise him of what could happen if he were to violate a condition of his release?
There could be a motion to modify and your release.
Can we take into
That's
custody,
true.
all right? I think that's been clear.
Could be revoked. All right?
But a lot of them
Thank you, Your Honor.
Where do I go?
do work, you know,
I'll walk you to the
still
second floor.
in the background.
Okay.
You know, make the
And there,
calls.
I don't know
mean,
if you can get it online.
that stuff's important too. The emails, the calls, that shit is important. Otherwise, I mean, just go do it and, you know, don't record any of it. You know what I mean? Like, it needs to get exposed. It needs exposure. It is 1:30 in Arizona, right? Or in Tucson? Well, what happened at this so-called hearing? It's happening right now. That's right, Special K. I'm at a loss here. He would have support if he had not notified us in advance and not burned all bridges. Tucson Police, are you talking about Lane? 150? Thank you very much. I'm not sure what he would have done to burn bridges. I'm hearing mumbles too, but it's not. I take it that you didn't go up there then, Prophet, huh? Text me, bro. I don't think, I mean, I don't know, man. I think they took him too.
I would be very happy to do that, but I was advised by the people downstairs that is not possible.
I mean, if you can, you know.
Let me know when you're ready.
This is a public service.
I was ready in October of 1982.
Are you ready, Mr. Myers? All right, you gave me the thumbs up. Thank you.
Yes, sir. Yes, Your Honor, I'm ready.
So, Mr. Myers, the way it works is I listen to everybody. When someone makes an objection, I listen to them. Then I'll give you a chance to respond, and then I'll rule on the objection.
Thank you.
And you just need to take turns talking, and I get to control that since I'm the judge. So, Ms. Walker, you were making an objection. Are you done with your objection?
I have to read it in full, if that's helpful, but I think I got through about half of it. But the two main points are that by Mr. Myers live streaming right now, it's actually part of what has caused so much harassment for me, as well as others to shoot.
I'm listening.
Thank you.
So I do believe that that is a violation of the injunction as it's written.
Thank you. Mr. Myers, are you broadcasting what you're reporting right now?
122H of the Arizona Rules of Procedure.
Mr. Myers, just answer my question. Are you broadcasting?
Yes, I am, and I'm allowed to.
And that's your reading of the rule?
Absolutely, and we can, if we want to argue, we should do it in a contempt hearing after, not in the middle of my injunction hearing.
Anything else you want to say?
Me? Yeah, absolutely. If you're saying directly the response to that, right?
The objection.
Yeah, that's what I mean. Reply to her.
Anything else?
No, I'm saying I want to reply to her objection. Is that what you're asking me? Yes, I do. I want to. The reason, and I've verified this with the Supreme Court multiple different times, the reason 122H exists, I can literally walk in here without, I did you a favor and notified you ahead of time today. I could have showed up at that door, and as soon as you walked in the room and you said, Your Honor, under 122H, I'm audio recording, and that's why in the rule, coverage is defined as cover and coverage. Broadcast is a separate definition under audio. This is the literal reason. You give out a Zoom link, what do you mean? That's not even an eligible argument because C, if I was requesting coverage under C, you can object. There's no objecting under H because people can walk in and say, Your Honor, I'm I'm
Mr. Myers,
under H.
Thank you.
You can't, there's no
Myers,
objection to that.
Mr. Myers, I've heard enough. Thank you. The objection is overruled.
Thank you.
Next thing I would like to talk about is, I don't know that we'll have any more hearings on this case, but Mr. Myers, you did email my staff ahead of time.
Yep.
And I don't mind that for logistical type reasons and scheduling type things, but emailing substantive stuff about notices and filings, make sure that you just send my staff things that you've actually filed rather than just emails with substantive stuff in it, if that makes sense.
Yeah, I called and asked if they want me to send it as an attachment or file it through the court somehow. She said to email it to her.
Right, but just make sure you just, when it comes to substantive stuff, that you only email things you've been filed as opposed to an email that includes a bunch of citations and things along those lines. Does that make sense?
Yeah, you're talking about don't send the request to you?
You can only email me substantive things that you've actually filed with the clerk's office.
Okay.
If that makes sense.
Yeah, we didn't need to do the notice with the clerk. That's why I was confused. The notice, it literally says to file it with you, not the clerk.
Well, for example, you sent me an email, you sent my staff an email that had case citations.
Yeah, so that they had it ready for you today.
What I'm asking you to do is you need to file that stuff with a formal file.
Oh, I see what you're saying.
And then
I got it with me too. I got it with me. Yeah.
If it's important that I get it right away, you can email my staff.
I didn't want you to catch you out with case law and Westlaw and then be like, oh, we got to look it up or something.
Thank you.
Here's hers.
The next thing I'd like to talk about with Mr. Myers is the injunction that was issued. Are you contesting the whole thing?
Absolutely.
Certain aspects?
Every single thing of it.
All right, we have about an hour left today to get through this. Let me just make sure that we're all on the same page in terms of what we're doing here today. The plaintiff has the burden of proof by a preponderance of the evidence, a little more than 50%. The plaintiff has to demonstrate to me that the defendant committed harassment within the year. Harassment is a series of acts over a period of time directed at a specific person that would cause a reasonable person to be seriously alarmed, annoyed, or harassed, and in fact does so to the person and serves no legitimate purpose. The scope of what I'm looking at today is going to be limited to what's in the petition, what's been filed in the petition. Plaintiff goes first, defendant gets to respond, then plaintiff gets a rebuttal. For the plaintiff, what sort of evidence do you anticipate presenting today?
I believe I have about 12 exhibits.
Have they been marked?
They have.
Given to the clerk?
They were.
Have you shown them to Mr. Myers?
Yes, we shared a.
She gave me a disc, sir. That's kind of like 1980s.
Have you,
I was told I had to bring it on a USB stick. They showed up with a CD-ROM that we haven't used since 2001.
have you looked at those exhibits?
I can't.
Do we have hard copies of them?
They told me don't. I literally went and bought USBs just for today because that's how it was.
Let me ask the plaintiff, do we have hard copies of those exhibits?
I don't have. I have hard copies of the paper exhibits, but not of the digital ones.
The clerk have the
I just have the CDs right there. And then
How am I going to look at the exhibits today during the hearing?
I also have them on a USB, if that's helpful.
It's not helpful because I have to go get a separate computer from IT because I'm not allowed
Right.
to put those things in a court computer. So do you have hard copies of the exhibits today?
Not of. I only have those hard copy discs that we were told to. I was told to submit to the court.
I'm just not going to be able to look at them at the hearing. And I don't know how we get them admitted without somebody looking at them. Mr. Myers, I assume you're not going to stipulate to have them admitted without having looked at them yourselves?
Her evidence?
Or exhibits?
This is what she gave me.
Are you stipulating to the admission of what's in that disc?
Of course, I want to see it too. But does this court even have a way to play it over there?
Not right now. So,
Your Honor, we did come prepared with a way to play the exhibits, at least on my computer.
But not on mine.
Mr. Myers, you keep interrupting.
I'm not it.
So you have your own computer and you can show those?
Correct, I'm sorry, yes.
All right. Other than the 12 exhibits, what's your other evidence?
I have those exhibits, I have an opening statement if you would like to hear it, but if you'd like to go straight into the exhibits, I'm happy to do that as well.
Any other witnesses?
No.
Are you going to be the only witness from your side?
Correct.
Thank you. Mr. Myers?
Yes, sir.
What evidence did you anticipate?
What?
What evidence do you anticipate
The voice on, you got this in front of you, like the little order sheet?
That's the
injunction itself, the petition. I plan on introducing on the 9/12 a recording of the phone call, the voicemail, and a copy of the email and paper that I gave them already. And then I have all these YouTube videos, but I'm assuming they're gonna play my YouTube videos too. But I need to put them under me too because of a case I have to appeal. You know what I mean? So I'm anticipating having to give you separate ones of these, right?
Have you?
Each one needs to have a separate stick, right? That's what they told me.
Have you given that to the clerk
They said not to do it because I only had 3.
to mark as an exhibit?
They said 15 or less, you don't do that.
Have you given it to our clerk today?
This guy right here?
Yes.
Oh no, I thought you meant like downstairs. My bad. No, I mean, is that what I'm supposed to do?
Let me just ask our clerk, do you have any exhibits from the defense?
no.
No, I haven't. No, I didn't send them I was gonna send them to your email earlier, but she said don't do that.
Yeah, don't do that. Let's see what the plaintiff presents.
Thank you,
The
thank you,
plaintiff
thank you.
presents the same thing you're anticipating, and we only need to admit it once. All right, Ms. Walker, why don't you stand up and raise your right hand? Do you swear to tell the truth under penalty of perjury?
Yes.
All right. I don't need an opening statement.
Okay.
If you want to go right into it.
Sure. Honor, my first exhibits are related to September 12th, 2024.
What's the exhibit number?
Exhibit 1.
Can I say something real quick? Can we just make sure that we're on the same page? As far as I was concerned, the only exhibit she could bring we could talk about was these 5 things.
All of my exhibits relate directly to that.
Okay, I just wanted to make sure there wasn't introducing anything that wasn't on this paper. Thank you.
And just so we're all clear, it seems like we've all agreed that the evidence that I'm to hear today is limited to the scope of what's mentioned in the petition. There is some leeway on that, but that's the general.
Correct. Every single exhibit correlates to the things that are mentioned in the injunction.
Thank you.
Exhibit 1, Mr. Myers called me work number 520-771-2021 at 8:11 a.m. and going for a voicemail or pickup.
Yeah, I'm trying to talk to a couple people in the background, guys, to figure out what's going on.
Hi, my name is Lane Myers, 520-771-2021. I see you're Director of Special Projects. Well, I'd like to ask if you could approve a special project where you help me end your husband's career for being a crooked-ass cop, prosecutor, wannabe, whatever he is, hiding these cops from prosecution. I figured the U of A, maybe Stacy could help me. Maybe I should talk to you or Stacy or maybe one of these. Because, you know, my wife also is an alumni of the College of Law and is actually has taught there. So, like, we got two sides that are about to come crashing together here. So, you can help me teach your husband how to follow the law, or I'm going to take his career. So, I figured since I'm a member of the community and my wife's an alumni of the law school, that maybe I can get access to the materials at the law school in order to fight for justice, since Stacy's all about justice. So I guess I got to call Stacy next.
That's the conclusion of Exhibit 1.
Are you moving for the admission of Exhibit 1?
Yes, I am. I would like to admit this voicemail.
Any objection, Mr. Myers?
Nope.
It's admitted. And the phone number that was called, is that a work number or a home number?
That is my personal work, or my work number at the University of Arizona, 520-626-9223.
And what do you do at the U of A?
I work at the College of Law. I'm the Director of Special Projects. I work with the Dean.
Mr. Myers, you have your hands up.
Oh, I mean, I don't know how to, like... Well, I wanted her to finish and then... Because I want to make a judicial notice of adjudicated fact.
Well, hold on one second.
Okay.
You can object.
I see what you're saying.
There's an objection, and you need to tell me what that legal objection is.
So you're going to let her finish her little presentation on all the exhibits and then I go, or each exhibit and then I go back at her?
So she gets to put on her case.
All the exhibits.
Her entire case.
Okay.
If there's something you object to, you're allowed to make those objections.
In the moment?
In the moment, if it's a legitimate objection. Sometimes that's in the eye of the beholder.
I just wanted to make it known that she is an employee of the state of Arizona.
Mr. Myers?
Okay.
Let me finish.
All right.
I talk slowly, and so if you hear a pause, let me keep going. Once she's done with her case, then you get to present your evidence. Thank you. Go ahead, Ms. Walker.
Thank you. Exhibit 2 is a paper exhibit. Zoom automatically emails me a document that has a partial transcript when someone leaves me a voicemail. It also has my phone number and the phone number that I received the voicemail from. And I would like to support this, submit this supporting documentation for this call as Exhibit 2.
Any objection?
No, I called her. That's my phone number.
All right. Exhibit 2 is admitted.
The next exhibit is Exhibit 3. I believe this is the same exhibit that Mr. Myers brought. Mr. Myers emailed my husband at 8:19 a.m. stating...
Objection, Your Honor. This is her husband. The plaintiff is the plaintiff. What I sent her husband is not relevant.
Objections overruled.
Thank you.
Stating that he was going to visit me at the law school and reference visiting our neighbors when attempting to cite our home address. This email is Exhibit 3, and I would like to admit this document.
Can I see it?
I also brought that too.
looking at Exhibit 3, it's an email dated September 12th of 2024. Mr. Myers, is that the same one you have?
September 12th at 8:18. I see your wife works at the U of A Law School. How ironic. Yeah.
Ms. Walker, what does your husband do?
He is a prosecutor for the city of Tucson.
And does he have any connection with Mr. Myers?
Yes, he was prosecuting a case that Mr. Myers was a defendant in, and he was the defendant at the time that Mr. Myers contacted me.
How do you know that?
I learned that after the fact when I received this voicemail. But at the time, he was still the prosecutor in the case.
Thank you. Go ahead.
The next exhibits are related to September 23rd, 2024. I would like to submit.
Objection, Your Honor. That's not on here. There's no date of September 23rd on here.
Hold on 1 second. I don't know if I said Exhibit 3 is admitted.
Oh, no, sorry.
It's admitted. And then the next exhibit is with references what?
September 23rd, 2024.
That's not admissible.
What's the objection?
Oh, September. I apologize. My bad, Shannon. I apologize. I didn't see the second one. I thought it was 10. Go ahead. Sorry, go ahead.
Thank you for withdrawing that objection. Go ahead.
Exhibit 4 is a video that Mr. Myers posted on his YouTube channel discussing my husband and I. May I play Exhibit 4?
How long is it?
It's probably about 10 minutes. There are specific parts that are referenced in the injunction that I was going to show. The language that I referenced, I was basically going to just go to those parts as opposed to play the entire video.
That's not fair. Objection. Context. And we'll be here for, it's about an hour video. Some of these videos are over an hour, 2 hours long.
Can you lay the foundation for the video?
Yes, I can. The video is important because it's when
How do you know what it is?
my face, my name, my contact.
The only news I have is that it's not good
Yes, I
as of
did.
right
Yes,
now.
I've seen it
So
myself multiple times.
I don't know exactly what that means, but he's
Exhibit
not
4 is
live,
admitted.
so we already know
We're not going to spend
that
10 minutes
much,
right
right?
now looking at it. Your next exhibit?
That is the only exhibit from September 23rd, 2024. My next exhibits are related to October 2nd, 2024.
This is Exhibit 5?
Correct. Exhibits 5, 6, and 7 are related to this. Exhibit 5 is also a YouTube video that Mr. Myers displayed on his YouTube channel. I'm happy to play the parts that are referenced in the injunction if you would like that.
How long is it?
There are.
Sir, that's going to violate decorum in this court, like confirms that there's going to be some, but I mean, it's all legal, but you're going to, is there kids in here or anything?
What's the objection? I'm just asking her how long the video is.
The part I would like to play is when Mr. Myers specifically states that I got his wife fired, which he has used as the foundation for his harassment.
Objection, Your Honor. That's more along the lines of defamation, not harassment.
Objections overruled.
Thank you.
Can you lay the foundation for this one?
Yes. Much of the harassment that I have received from Mr. Myers, and as you'll see in subsequent visits from his followers, were based on Mr. Myers claiming that I did something to have his wife fired from her job. And this is the first time that is explicitly stated in any.
That's Exhibit 5?
Correct.
That's admitted. The next one?
You don't need to play, Your Honor?
No,
Okay.
Yes, I'm sorry. I said not good. Not good is what I said. But I don't have details as of this second. We'll see if we can get Dick Tracy here in a minute if something.
The next exhibit is a paper exhibit. In the comments of this video, Mr. Myers responded to a question by stating that I was involved in his wife losing her job. I would like to admit this as Exhibit 6. It's the comments from the YouTube video, specifically when someone asks him if they, meaning myself, and I'm not sure if he means my husband or a colleague, were personally responsible for his wife losing her job.
And you have a copy of Exhibit 6? Would you hand that to the clerk? Clerk will hand it to me. I will take a look at it. And how do you know that these are the comments to the video that's Exhibit 9?
The comment that I want to admit is made by Mr. Myers under his handle, that all of these exhibits are, that is his YouTube channel.
Any objection to Exhibit 6?
Yes.
What's the objection?
Okay, what other people said have no bearing on this case, and it's First Amendment protected activity on my YouTube channel.
The objections are overruled. Exhibit 6 is admitted. Exhibit 7?
The next exhibit 7 is also a paper document. Mr. Myers, using the same handle, posted a subsequent comment with my name, place of employment, and stated that my phone number and email are public information on my workplace website. I would like to admit this document.
How do you know that that's what it is?
It's under the same Lane Myers 2980.
That's me.
handle.
That's me.
Thank you. Any objection to Exhibit 7?
No, sir. No, Your Honor.
Thank you. Exhibit 7 is admitted.
The next set of exhibits are from October 8th, 2024.
This is 6 or 7, I mean?
October 8th.
We're on Exhibit 8.
8. Sorry, I apologize.
Your Honor, this exhibit is a video from YouTube. Mr. Myers posted another video in response to a motion that my spouse filed in his Tucson City court matter. In this video, he again displays my name, picture, contact info, and room number from the U of A website at approximately 54:58, telling people watching the video to, and I apologize, share the fuck out of this. He stated that all the motion was going to do was lead to his wife getting phone calls and emails at approximately 1 hour and 18 minutes. He also said, I guarantee you, I'm going to go to the U of A Law School and ask to speak to me at approximately 1 hour, 29 minutes, and 48 seconds. And I would like to admit this video as Exhibit 8.
How long is it?
It's because many of these videos are long. These are the specific parts that are referenced. I do have the timestamps, and I'm happy to go to them if the court thinks that would be helpful.
And how do you know this video is what you're saying it is?
It is the same video, the same YouTube channel.
You watched it personally?
I've seen it, yes, I've seen all of these videos personally.
Any objections?
Yes, Your Honor. This is getting bad now. Okay, so I got to stand up for a second. All right, so these videos are hours long. The way that you're letting her admit these, it makes it seem like I created this video and it's 14 minutes or whatever about her. That's not true. It's 2 hours. It's not fair. It's about my public record, about my case, about my motions in my case that are public records.
What's the legal objection you're making?
She's not giving the full video. You need to play the full video.
The objection's overruled. Exhibit 8 is admitted.
Your Honor, would you like me to play?
No, thank you.
Exhibit 9 is a paper exhibit. After this video, I received 4 phone calls from different numbers. These calls are depicted on Exhibit 9. I would like to admit this document, which shows phone calls that I received from various unknown numbers immediately after Mr. Myers' live stream video.
And the phone calls are to what number? Your work number?
They are all to my work number that was shared by Mr. Myers and that he encouraged people to reach out to me at.
And I was looking at something else, I apologize. Say that again?
They're all to my work number, and they happened immediately the same day after Mr. Myers' live stream and encouraged his followers to reach out to me.
Any objection?
Of course, sir, that's mental gymnastics. There's no way to prove that these people called because of me, and you shouldn't be giving out people's numbers. She's so worried about all this. Why is this being put on a public record? These random people that we have no way of corroborating if they were calling on behalf of me.
What's the legal objection?
My legal objection to her?
To the admission of the exhibit.
We have no way of knowing that these had anything to do with me.
Right, the objection's overruled. Exhibit 9 is admitted. For Mr. Myers, I hear what you're saying there. That's something for me to decide based on the weight of the evidence. If I can.
I'm gonna get to argue that, right, when it's my turn to go back? Right, okay, cool. That's what I thought. I wasn't sure if I had to make those legal arguments right now or just.
Again, you're interrupting me. I don't think you need to, but you're interrupting me. based on the evidence, I have to figure out, I want to draw an inference that you're causing this or people are acting in this way. We're on Exhibit 10, I believe.
Yes, Exhibit 10 is a voicemail. It's about 30 seconds. I specifically received 2 calls and voicemails from Deborah Moore at 360-633-9136. The first voicemail is Exhibit 10. May I play this exhibit, Your Honor?
How do you know what it is?
It is someone that...
You listened to it?
Yes, I have. I've listened to it myself.
Recorded it off your own phone?
Correct. It came directly from my workplace.
Any objections to 10?
Of course. Who is Deborah Moore? I've never met her in my life.
All right. The objection is overruled. You can play, Exhibit 10 is admitted and you can play it.
Thank you. And I will note that you can hear Mr. Myers' video in the background of this voicemail.
This is not on the paper, sir. It's not on here.
What's the objection?
This is not on here.
You say this?
These phone calls were not mad. These were not on the petition. Nothing about other people calling her are on this petition as an act leading to of a harassment. This is all going off the rails. You're just, where is show me Deborah Moore on the petition. Show me the name Deborah Moore on the petition.
Mr. Myers, what I'm hearing you say is you're objecting that the evidence is beyond the scope of the petition.
Of course. It's not even on. Who's Deborah Moore?
You're interrupting me. A couple things. You seem like you're getting angry. Your tone of voice is changing. It makes it hard for me to pay attention when that's going on, so I'll ask you to lower your voice. Second, in my opinion, this is all within the time frame and the scope, and the petition does mention getting phone calls, so I think this falls within the scope of the petition. Go ahead and play the objection's overruled. Go ahead and play phone call. That's Exhibit 11, right?
This is...
Explaining the judge. You see other things. Oh yeah, my confidential informant Mackenzie O'Brien doesn't feel safe. She doesn't have any fucking rights because she lied. You're fucked, bitch. You're fucked. You fucked
That's
up
not me.
during that fucking idiot. You're gonna drag on 30 dick drag guy. So you're fucked. Matt Walker, the fucking responsible piece of fucking garbage. Are you worried? He's going down. He's gonna wind up in fucking prison. You're gonna wind up in prison next to him. The general populace is gonna own all your fucking property. Stuff. What happened? Someday, this is shit. You are done.
And that was Exhibit 10, and that was a voicemail message left on your work phone?
Correct.
Thank you. Exhibit 11?
Exhibit 11 is a the supporting document for that voicemail that I received on my personal work line from Zoom. I would like to admit the transcript and the phone call evidence of that exhibit.
Any objection to 11?
Yes.
What's the legal objection?
It's irrelevant and it's not in the scope.
The objection is overruled. Our last exhibit?
Yes, Exhibit 12 is the second voicemail that I received from this same individual. I would like to admit this voicemail as Exhibit 12. It's also about the same amount of time.
And this is one you listened to on your own voicemail?
Correct. Listen to it personally on my work voicemail.
Any objection to Exhibit 12?
Yeah, it's from a random person that has no connection to me.
All right, the objection is overruled for the same reasons. Go ahead and play it.
Are you the dumb shit that married Matthew Walker? If you are, you're going down in flames. Okay? Honey? Honey, just so you're aware, you're fucked. You're literally fucked. People are going to be fixing your ass in a prison cell for your corrupt husband and your criminal behavior. You're fucking criminals. You think you can pervert justice? We, the people, will own your ass. Literally. And figuratively. Get ready, bitch. Get ready. This fucking is coming. We're gonna fist fuck your ass. Get ready, honey. Shannon. It's coming. You fucked up, honey. You married a fucking ignorant boob. You married an ignorant fucking boob. And he's gonna get you in a whole world of shit. You already had it. You just don't realize it. You're gonna realize it tomorrow. I guarantee you're gonna realize it tomorrow. You're fucked. All the fucking legal fucking maneuvering and wrangling, you ain't gonna fucking do shit. You're gonna dig your fucking hole even deeper, you stupid cunt.
Mr. Myers, when that video was playing, it seemed like you were trying to hold back laughter, and then you kind of raised your fist up as if you were supporting the comments that were in there.
No, my suit's a little short.
I don't believe you.
Okay, well.
That's what the court's putting on the record. That's what it looked like to me.
That what?
You were laughing and enjoying what you were hearing, and that you were supporting those comments.
I couldn't have been laughing at my text from my girlfriend?
You could have, but I just don't believe you.
Oh, okay, that's
I was
fine.
watching you closely.
Well, the record will state I got a text from my girlfriend telling me to calm down, but okay. Yeah, roll your eyes.
Again, I don't believe you. I'm just making.
I don't believe you.
That's all right. You don't have to believe me. Your next evidence?
Yes, Your Honor, I apologize. I said there were 12 exhibits. There are actually 13. If you'll permit me to commit the transcript of the voicemail that I received on my personal work phone and have listened to myself.
All right. Any objection to 13?
Of course.
What's the legal objection?
Out of the scope.
Objections overruled for the same reasons. 13 is admitted.
Oh, I'm sorry, Your Honor. There is one more final exhibit.
14?
This truly is the last one.
I don't have that.
It relates to October 9th, 2024.
Let's see what it is.
I don't have it.
1 second. Let's see what it is.
This is a live YouTube video on Mr. Myers' channel. He went live on his YouTube channel and came to the law school to look for me. This video is Exhibit 14. Mr. Myers first stands outside of my office door, approximately 5 minutes and 15 seconds of the video, matching my office door to what is on the website. My nameplate is no longer on the door because it was removed from the door on the advice of the University of Arizona's threat management team due to Mr. Myers' actions toward me. Mr. Myers asked various colleagues where I was and stood outside my office at approximately 7 minutes and 30 seconds. He tells my colleagues that he wants to interview me because I got his wife fired from her job at approximately 15 minutes and 20 seconds. And near the conclusion of the video, he states that he would have to try again to come talk to me at 28:11. I would like to admit this video.
And this relates to the allegations on October 9th of 2024?
Correct.
And you know this is the video because you watched it?
I did watch it myself.
Any objections to 14?
Yeah.
What's the legal objection?
Constitutionally protected activity.
That objection is overruled. It doesn't prevent it from being admitted in evidence. It's admitted.
That is the conclusion of my exhibit.
Any other testimony from you that you want to have in your case in chief? And if so, you can head to your table.
I think I am finished. Should I leave the exhibits here?
Yes.
Okay.
And once you head back to your table, I'm going to have some questions for you.
Of course.
Your Honor, should I give these sticks to him right now?
Not right now.
Okay.
Ms. Walker, how were the YouTube videos brought to your attention?
I've had initially a number of people reach out to me to say, I heard about this. I've had colleagues who have seen them and sent them my way. Also through my spouse and his work. I just became aware of them and in Mr. Myers' channel. I'm sorry, I can't remember how I originally learned about it.
And in the videos, according to what you've seen, Mr. Myers gives your name and phone number?
Correct. My name, my phone number, all workplace phone number, email office number encourages his followers to come visit me and says anyone can come visit me, and obviously visited me himself.
And does he say why they should come visit you?
No, my impression has been that it was all so that I could be intimidated, and by extension, my husband, out of no longer prosecuting his case.
And from your perspective, is there any reason Mr. Myers should be having any sort of contact with you?
Absolutely not.
And have you ever told him to stop having contact with you?
We've never spoken. I've been afraid of him. But, Your Honor, I will add that Mr. Myers has never in any way indicated why he would reach out to me for any other reason, and he has explicitly stated it was because I'm married to Matthew Walker, who is the prosecutor, or was the prosecutor in his case.
Thank you. Any other evidence?
No, thank you, Your Honor.
Mr. Myers, it's your turn to present your evidence.
How do you want to do it if it's the same thing she already?
You don't need to, it's been admitted.
So we can both use that. I can call up exhibit.
You can refer to it.
When it's my turn to go up and present and stuff.
You can refer to it. I don't know that I'm gonna let you play it because.
So if I want to play it, I need to go through the same thing she just did.
No, you can reference it. It's already been admitted. Just tell me what it is and what about the exhibit you want me to focus on.
Well, I want to admit it so that I can play it.
I'm not going to allow it to be played. We don't have the time today to do that. So you can summarize what's in the video and what you think is important about it.
So we're not going to actually watch the video that led to an injunction?
Not right now. You can tell me all about it. Tell me what you think is important about it. It's been admitted.
About her. Am I supposed to be rebutting her evidence or presenting new evidence?
It's your case. It's your
I thought you
time.
wanted me to come up there with the computer.
Karen, I got it. I got it. Thank you, Karen.
Don't I got to bring this over here?
No,
Oh, okay.
you don't.
She said to play it on there, I do.
It's already been admitted, so
Well, I have different videos too.
what exhibits do you have that are different?
A recording of the hearing with her husband where he asked for the same thing and got denied.
Why is that relevant?
Because her husband, before this injunction was issued, her husband tried to get one for the same reason and a judge denied it.
All right, I'm finding that's not going to be relevant.
No, for her, he tried to get a court order. Listen, maybe I failed to articulate myself properly. Listen, the case she referred to about him prosecuting, he came to court and asked the judge to issue a change of conditions of release that I couldn't contact his wife or make videos about his wife or say anything about his wife, and the judge looked him straight in the face and said, he's a news reporter, it's First Amendment activity, I can't stop him from doing that, he's not breaking the law. So what'd they do? They went over to Judge Walton and tried the same thing that they just got denied with the day before.
All right, that's not relevant for what I'm doing here today. I'm my own judge, I get to make my own decisions on it.
Another judge denying it is not relevant?
Doesn't bind me right here, right now.
So you're denying my exhibit?
Yes, I don't think that one's going to be relevant. Do you have another one?
Am I going to get a chance to make legal arguments?
This is your chance to present evidence. After everybody's done with the evidence, then I'll hear a closing argument.
Okay, so you see, so I want the email for sure.
I'm not sure you say the email.
The one that she put in here. The one that we said where it says.
I'll take it too.
Oh, but
That's okay. Thank you.
I see your work for you, right?
That's been admitted. I can't remember what exhibit it was. But
So anything that she already put in that I want to use, don't talk about right now?
you can talk about it, but I'm not going to allow videos to be shown.
I get what you're saying. No, I'm saying, right now we're just saying, do I have anything to add to this, essentially?
Any additional evidence?
Right, other than this. And that's what I'm saying. I wanted to add that hearing. Okay.
And I'm finding that that's not going to be
Okay.
relevant.
And you're saying with other parts of the same video, she wants to admit, there's a video on October 2nd. She wants to admit one part, I want to admit a different part.
My understanding is
She edited hers down to like a little clip. I want to play the whole video. I want to admit the whole video for context. Yeah, that's what I'm saying. That's on the sticks.
Then which stick? Show me the stick.
Yeah, these. I got one for exhibit 1.
You'll be letters.
Hey, I'll be letters? Okay.
How many do you have?
I have 2. If you're not going to let me write no on the other one, right?
No on the other.
Okay. Yeah. So I want to do 2. I want to do
So what will exhibit?
We want to call it A.
What will exhibit A be?
A is the video where I went to the school that she was referring to.
Okay.
That I stood outside her room and all this. That's the one I just gave her. So that's exhibit A. That's the whole video, not the little 2 minutes that she wants to show. That's
Okay.
That's going to show proper context of the news report.
1 second, let me see if there's any objection to that.
No, I don't have an objection.
So Exhibit A is admitted. Do you have another exhibit?
Yes.
That'll be B as
Yes. This one is the one she was referring to. Let me see what I want to label this. Like I want to, because I know it needs to be contextualized the right way. Oops. Can I see that one for a second, just because I want to make sure I'm not giving the same thing twice. I apologize. I thought there's really no way to write on them or anything. Okay.
Is that still there?
Yeah, it's still A. Still A. I'll just have A. The whole video.
Do you have any other exhibits?
No. We got the voicemail. Like, I don't need to give you a stick with the same voicemail that she admitted, right?
Correct.
Okay.
And is there anything about Exhibit A that you want to highlight for me right now?
Me?
Yes.
Specifically, yes, my interactions with the staff throughout the whole video, from the time I walk up there, that I ask if it's public. Am I allowed to be here? Am I allowed to go in this space? Her colleagues tell me, yeah, go ahead. You want me to go get her for you? They didn't say, oh my God, you can't be here. You got to leave. They said, sure, we'll go get her right now. You want to go to her office? We'll walk you to there. I said, well, I don't want to go to her office. I don't want to like have her open the door and Lane Myers is standing there. I went there intentionally when she was not there. And that's what the video is going to show.
Okay, thank you.
I rejected, her colleague did offer to take me and I said no.
Any other evidence you want me to hear?
Evidence?
Not argument, but evidence.
Evidence, that's what I'm saying. No.
Let me ask you something.
It's self-explanatory that the petition's going to be in there, right?
Yeah.
Okay.
Part of the profile. Let me ask you some questions then.
Sure.
One of the things that I'm going to be asked to think about is whether or not you have a legitimate purpose.
Of course.
For your interactions. What is your evidence that what you're doing when you interact with the plaintiff is for a legitimate purpose?
So you're asking me to make a legal argument?
I'm asking if there's any facts that you want to tell me about that would
Material facts?
prove that you have legitimate
Yes, absolutely.
for what you're doing.
Absolutely. You want me to start now?
Facts, not the argument.
Oh, not
facts.
The facts? Yes. The facts are that the facts of why I initially contacted her were pretty self-explanatory in the voicemail. The reason I felt I could contact her because she's a state employee. She's a public employee. She receives public funds. It's First Amendment protected activity. I looked at we can't make legal arguments. I looked at the injunction for harassment rules. She didn't meet the standard. She never told me to stop contacting her ever in my life. I've left one voicemail ever, and she's never told me to never contact her again. All of a sudden, there's this injunction. So, like, if one of the standards is there needs to be more than one, and you need to be told that you're harassing me. I was never put on notice. And first of all,
why do you think you need to be told?
Because if somebody's being harassed, you can't just allow the other person to keep harassing them and not tell them. If you feel you're being harassed, she needs to go to, like she said, she went to the law enforcement. We'll get into that. But the facts are that she's a public employee. Her email is .edu. Her phone number is listed on a public website, just like your phone number is on a public website, just like your email is on a public website, just like your name's on a public website. You're both employees of the state of Arizona. It was a legitimate business. I didn't mention the case in detail, all that. I assume she didn't know nothing about it, but now she's saying her husband was talking to her about it. Well, that sounds,
this seems more like argument.
I feel you.
Any other evidence?
No, evidence-based talk. No. If you want me to get into my law argument, no. Okay.
Thank you.
Case law and stuff, no.
Ms. Walker, rebuttal evidence? Testimony, anything?
Your Honor, I think Exhibit 1 speaks for itself. Mr. Myers left a voicemail saying he wanted to speak to me about my crooked-ass husband who's a prosecutor. He did not once ask to speak to me about anything that the law school does. He asked to speak to me about my husband who's the prosecutor in his case.
Who's also a public employee.
1 second. Give me some more detail about what your day-to-day activities are in your job.
I work specifically for Dean Miller. I write his letters, his remarks. I work with various legal boards. I work with attorneys. Mr. Myers is not an attorney.
Do you have any connection with your husband's office where he works?
Do I personally? We work together occasionally. My husband is an alum of the law school, and Tucson is a small legal community, as I'm sure you know. And there's just
in your capacity in your job, do you have any connection with the city attorney's office?
Not really. Not really.
Yes or no?
Mr. Myers, you don't get to say that. I'm asking the questions. To my ear, that sounded kind of rude.
My
so
bad.
Please stop.
No, Your Honor.
All right, I've heard all the evidence. Now I will hear oral argument. We'll start with Ms. Walker because she bears the burden of proof. In terms of the elements of harassment, just walk me through why you think they've been met. And then when I look at the injunction, there is some language in it that does concern me in terms of its overbreath. The last sentence says the defendant is prohibited from posting any messages or content regarding the plaintiff via any social media platform. That strikes me as broad and probably too broad for constitutional First Amendment type issues. So I'd like to hear your thoughts on that and whether it could be narrowed in a way that would make it constitutional.
So to your question, Your Honor, harassment is conduct, not speech. I have copies of Arizona Court of Appeals cases, State v. Brown from 2004 and State v. Snyder from 2024, further explaining that if the court would like to review those. I'm not asking the court to restrict Mr. Myers' speech on political matters or general topics, but Mr. Myers has harassed me personally and posted videos about me on his YouTube account. In those videos, he has posted my place of employment, work email and phone number, and office number, and asked his online followers to harass me as well, which they have done many, many times. Thank you.
And the elements for a series of events and why this is harassing and whether or not you actually felt harassed?
In terms of the, yes, it does.
What are the series of acts?
Well, I believe that is shown in my injunction.
I'm just asking you to walk me through it.
Of course. Would you like to go by date?
The first date, when you make the phone call. The other one, September 23rd, October 2nd, October 8th. Let's just take September 23rd.
Sure.
The YouTube channel, that was not sent to you, right? Somebody told you about it?
Someone told me about it, and then I went and viewed it myself.
So, in my mind, it's hard to see how that's directed at you.
I think Mr. Myers says in the video that he's studying his opponents and specifically shows my photo after that. And this was also right after he showed my husband's contact information as a prosecutor and implied that I am his opponent.
It's definitely about you, but I don't know how it's necessarily directed at you. The second saying these videos were not sent to you, someone told you about them.
Correct.
October 8th, there are people calling you. Your petition says that the videos were encouraging, that Mr. Myers was encouraging his 8,000 plus followers to contact you.
Correct.
What makes you think that he was encouraging them? What in the videos supports that?
He explicitly asked his followers to share my contact information and to reach out to me. And the justification was that I had his wife fired.
All right, guys, the hearing's on the channel,
Then,
so if you want to see the rest of this hearing, it's on the channel. So check it out. It's called Captain Kangaroo Hops Off His Rocker, Hero, Public Landowner, Defends Free Speech. Justice for one more day, everyone. For one more day. Don't forget about that contact info at the top of the chat, guys.